Welcome to Law Logical, your guide to the intricate world of law, explained in a logical and simplified manner. Today, we're diving into a subject that is often shrouded in complexity and misunderstanding: divorce. However, it's important to remember that divorce should always be the last resort. Giving a marriage a fair chance is a crucial step that should never be overlooked. Our aim in this video is to demystify the legal procedure for divorce, specifically in India. We'll navigate through the maze of sections and acts as per Indian family law, breaking them down into digestible chunks. By the end of this video, you'll have a clearer understanding of the process and what it entails. It's our belief that knowledge is power, and we hope that this video will equip you with the information you need should you ever find yourself in such a situation. Remember, every effort should be made to save a marriage before considering the legal route of divorce. In India, the grounds for divorce are clearly defined under the Hindu Marriage Act, 1955, and the Special Marriage Act, 1954. These acts outline several circumstances under which a marriage may be legally dissolved. Let's delve into these grounds. Firstly, we have adultery. This involves either spouse having an affair outside the marriage. The law considers this a violation of the sanctity of marriage and provides it as a ground for divorce. Next is cruelty. If one spouse subjects the other to physical or mental harm, it's considered cruelty. It's important to note here that mental cruelty is taken as seriously as physical cruelty in the eyes of the law. Then comes desertion. If a spouse abandons the other without a reasonable cause for a period of not less than 2 years, it's considered a ground for divorce. Conversion is another ground. If a spouse changes their religion without the other's consent, it can lead to the dissolution of marriage. Next, we have the clause of mental disorder. If a spouse is incapable of performing the normal duties required in a marriage due to any mental illness, it can be a ground for divorce. Communicable disease comes next. If a spouse has a communicable disease which could potentially harm the other, it's another ground for divorce. Renunciation of the world is an interesting ground. If a spouse decides to renounce the world and lead a religious life, the other spouse can seek a divorce. Lastly, presumption of death. If a spouse has not been heard of as being alive for a period of 7 years or more, the other spouse can seek a divorce. These are the grounds for divorce recognized by Indian law. It's important to remember that these laws are in place to protect the rights and interests of both parties in a marriage. Divorce is a serious step, and these grounds ensure that it's not taken lightly. Once the grounds for divorce are established, the next step is filing for divorce. This process, while perhaps daunting, is an essential step towards legally ending a marriage, and understanding it can make the journey a little less overwhelming. To begin, it's crucial to hire a competent lawyer. This professional will guide you through the legal maze, providing necessary advice and representation. They will help you understand the complexities of the Indian family law and how it applies to your situation. Remember, the right lawyer can make a world of difference in your divorce proceedings. Next, you and your lawyer will work together to prepare the divorce petition. This document is a formal request to the court to dissolve your marriage. It outlines the grounds for divorce, as discussed in our previous segment, and presents your case in a legally structured format. This petition must be prepared with utmost care and precision, as it forms the basis of your divorce case. Once your petition is ready, it's time to file it in the court of appropriate jurisdiction. This is typically the family court in the district where you and your spouse last resided as a couple, or in some cases, where your spouse currently resides. It's important to file your divorce petition in the correct court to avoid any legal complications down the line. After filing, a copy of the divorce petition is served to your spouse, signaling the start of the divorce proceedings. This gives them an opportunity to respond and present their side of the story. It's a reminder that divorce is a two-way street. Both parties have a voice in the matter. In essence, Filing for divorce is a delicate process that requires a deep understanding of the law, a well-prepared petition, and the right legal representation. It's a formal declaration that you're seeking to end your marriage, and it sets the wheels of justice in motion. Filing the petition is the formal start of the divorce process. Now that you've taken this step, brace yourself for the proceedings that lie ahead. But remember, you're not alone in this journey. With the right guidance, you'll be able to navigate this process with confidence and dignity. After the divorce petition is filed, the legal proceedings commence. This is where the wheels of justice begin to turn and the process of untangling two lives intertwined through marriage begins. Firstly, the court issues a summons to the respondent, which is essentially an official notice of the divorce proceedings. This summons contains a copy of the divorce petition, outlining the reasons for seeking divorce. This is a crucial step, as it ensures that both parties are fully aware of the allegations and claims made against them. Upon receiving the summons, the respondent has the opportunity to respond to the petition. They may choose to agree with the claims made or contest them. If they choose to contest, they must file a written response termed as a written statement within a month. This response should address each allegation, either accepting or refuting it. Following this, the court sets a date for the trial. The trial is an opportunity for both parties to present their case before the judge. They may do so through personal testimonies, witnesses, or documentary evidence. It's important to note that the burden of proof rests on the party making the allegations. It's not uncommon for the court to issue interim orders during the trial. These are temporary orders related to issues such as child custody, spousal support, or property disputes. They are meant to address urgent matters that cannot wait until the final decree of divorce. But remember, divorce is seen as a measure of last resort. Even during these proceedings, the court offers the possibility of reconciliation. The court may refer the parties to mediation or counseling in an effort to resolve their differences and save the marriage. It's a final attempt to rekindle the bond, to see if the cracks can be mended. However, if reconciliation fails, the court will proceed with the divorce. The proceedings are concluded only when the court is satisfied that the parties have been unable to live together and that there is no scope for reconciliation. The court makes every effort to reconcile the parties before moving forward with the divorce. It's a journey of patience, resilience, and courage as the court navigates the choppy waters of marital discord, always striving for resolution over dissolution. If reconciliation fails, the court proceeds to the final decree of divorce. This marks the last stage of the divorce process, a stage that is as critical as it is definitive. The first step towards the final decree is the presentation of evidence. Both parties are given an opportunity to present any evidence that supports their case. This could be in the form of documents, photographs, or any other material that can be legally admitted in a court of law. The evidence presented should be substantial and relevant to the grounds of divorce that have been filed. Next comes the examination of witnesses. Witnesses can play a pivotal role in divorce proceedings, substantiating claims made by either party. The court can summon any person as a witness if it believes that person has any knowledge of the facts of the case. Each witness is cross-examined by the opposite party to test the credibility of their statements. After the examination of witnesses, the lawyers from both sides present their arguments. These arguments are based on the evidence presented and the testimonies of the witnesses. The lawyers aim to convince the judge of their client's stance, seeking a favorable judgment. Finally, we arrive at the court's judgment. The judge, after considering the evidence, the witness testimonies, and the arguments of the lawyers, gives the final verdict. This verdict is the final decree of divorce, a legally binding document that dissolves the marriage. The court may also decide on matters such as child custody, alimony, and property division in this decree. However, it's important to note that the divorce becomes final only after the decree is granted. Until then, the spouses remain legally married. The final decree signifies the official end of the marriage, allowing both parties to move on legally and emotionally. The divorce process concludes with the final decree. This decree is the culmination of a long and often taxing process, marking the end of one chapter and the beginning of another. It is the final seal, the last word, the full stop that marks the end of the marital bond. And with it, the legal procedure for divorce as per Indian family law concludes. Divorce is a complex and emotionally taxing process. As we've discussed, it's an intricate journey through India's legal system. From understanding the grounds for divorce to filing your case, navigating the proceedings, and finally reaching the decree, every step requires careful consideration and attention to detail. Remember, this journey is not one you need to undertake alone. Legal counsel is not only advisable, but often necessary to ensure your interests are protected throughout the process. They can provide guidance, support, and expertise, making a challenging time a little less daunting. Let's not forget the possibility of reconciliation. During the proceedings, there's always a chance to reevaluate and perhaps find a path back to the marital bond. After all, divorce should always be the last resort. Thank you for joining us today on Law Logical. Please remember to like, share, and subscribe to our channel for more simplified explanations of complex legal concepts.